One plaintiff shouldn't control your payroll on Friday. If a surprise lawsuit could freeze the cash that keeps your business alive, that pays your employees, you're gambling with oxygen. So today, I'll show you how founders with $1 million to $10 million in cash separate operating money from reserve money and park the reserve behind the law that says no to the judge when you can't. I'm Kevin, the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I've been in the asset protection business for 34 years, setting up Cook Islands Trust for nearly 30, and our firm has set up more of them than anyone in the world. And if you lead a company with serious cash reserves, this episode is your playbook. So grab my free offshore banking checklist down in the description, hit subscribe for weekly playbooks like this, and schedule a consult at assetprotectionplanners.com. Let's get to work. You don't just have cash, you have two piles with different jobs. Operating cash, say 30 to 90 days of liquidity for payroll, vendors, taxes, ads, needs speed, and ACH. And then there's reserve cash, 6 to 24 months of stability so your company survives surprises. Needs safety, not convenience. If both piles live on the same U.S. rails with the same signature cards, your adversary can reach both with the same court order. One spark, the whole house. So in a few minutes, I'll show you the one-page document that makes plaintiffs reprice their case. First, let's fix the plumbing. And I hear this all the time. Business owners call us, they're in a panic, they're getting sued, and they're scared to death that the lawsuit is going to take all the cash out of their business, they won't be able to make payroll, and they'd be sunk. And in that case, they settle for more than they should because they feel very vulnerable. So let's go ahead and flip the script. Now, here's why U.S. banks are easy targets. U.S. bank accounts are fast for you and also fast for your adversary. I've seen a TRO, or temporary restraining order, at 10 a.m. and payroll bounce at 3 p.m. If you personally control all accounts, the other side only has to squeeze one human, you. Now, jurisdiction, on the other hand, is a court's power over people and property. If all that cash is onshore, the court's commute is short. If your reserves sit offshore inside of a Cook Islands Trust that owns a Cook Islands LLC, and we have a lot of videos about this and how this works on our channel, then the legal commute becomes a 6,000-mile swim against a riptide of protective law. Now, here are 3 ways that cash gets grabbed and how we block each. Tactic number 1, ex parte TRO. The other side asks the judge, without you present, to freeze all accounts in the name of X. If your reserves ride on the same rails as operating cash, you learn about that freeze when payroll fails. Blocker. Keep reserves offshore in the trust-owned Offshore LLC with a duress-ready trustee. So we're the biggest firm that sets these up. Onshore orders don't move those funds. So you have reserves. You don't have to live in fear that your business is going to crash and burn because of one lawsuit. Tactic number 2, bank levy / turnover. After a judgment or someone sometimes mid-case, a creditor serves your bank with a levy or a turnover order. Banks comply because they must. Blocker. Reserve doesn't sit in U.S. bank, and you don't control it under duress. Tactic number 3, personal compulsion. Bring it back or face contempt. This scares owners into volunteering assets. Blocker. Your pre-signed management resignation under duress means you can't comply because you don't control the reserve while under legal pressure. Okay, so the offshore reserve stack, the Trust plus LLC, we're going to go through the mechanics of how this works. Okay, So the architecture we implement for founders with $1 to $10 million in cash reserves: Cook Islands Asset Protection Trust, the legal fortress, short limitations, high creditor burdens. So let's illustrate this. This purple box represents your Cook Islands Trust. Why the Cook Islands? It has the strongest asset protection in the world. And like I say, the videos we have talk about this extensively. So there's your Cook Islands Trust, strongest asset protection tool, bar none. Inside sits your Cook Islands LLC, and you are the manager of the LLC initially. You're the signatory in the bank account. That's where you keep your cash reserves. So the Cook Islands LLC is owned by your trust. The vault room holds your offshore bank account. So you, as the LLC manager, while the skies are clear, you initiate wires, manage cash, rebalance currencies, licensed bonded trustee with a duress switch. So if a lawsuit hits, our law firm internationally steps in only to protect you, refusing the orders that jeopardize the trust. So when the storm passes, you resume control, management. In other words, U.S. court orders fall on deaf ears in the Cook Islands because U.S. judges don't have jurisdiction in the Cook Islands. This is how this works. Now, again, if you haven't seen some of the other videos, the Cook Islands is part of New Zealand. If you look up Transparency International's reports, New Zealand is one of the safest, most trusted jurisdictions in the world. It's been number 1, 2, 3, or 4 for the past, I think, over 20 years since they've been doing this survey out of 180 countries, most trusted, least corrupt country in the world. And I've been setting up trusts there in the Cook Islands for over 30 years, or right around 30 years. Never once have I seen anything but absolute impeccable integrity. So in other words, use when calm, protect when stormy. Speed and maneuverability in one whole. Okay, now I promised a one-pager that changes the math. We'll get there after the question that founders ask first: where does the bank actually sit? So choosing the bank. So where the LLC inside this trust holds the account. So why do we put an LLC inside the trust? Simple, because you as the manager are in the driver's seat when things are calm. But if you were in a position where a judge could order you to turn the money over, our law firm can step in as that LLC manager. So this gives an easy lever. You're not moving assets, you're simply moving management. And that way, when the judge says, hey, turn it over, you say, I can't. I have to go through the law firm in the Cook Islands, and the law firm is not going to comply with a U.S. court order because they don't have to. They're not under U.S. jurisdiction. So that's how your money stays safe. I have a Cook Islands Trust myself. We have set up thousands of them, and it's absolutely the most powerful asset protection there is. Okay, so let's choose the bank. The bank isn't the plan. The banking selection is tooling, not strategy. We work with stable, conservative institutions that understand U.S. founders and support multi-currency custody. Okay, non-negotiables: stable jurisdiction and predictable courts. And we often use Switzerland for the cash reserve account. Now, the trust and the company are in the Cook Islands, just like a Mercedes doesn't have Mercedes tires. It most likely has like Continental tires. The same thing here. We use the best jurisdiction for the different tools. The best asset protection jurisdiction, Cook Islands. Best banking jurisdiction in the world, Switzerland. The Cook Islands also has an incredible bank, but it has to be in the trust. If it's just the offshore company, if it's just the offshore account alone, the judge can just order you to bring it back. It's having the offshore account plus the trust in the LLC that provides the meat of the protection here. Okay, what else must the bank have? Strong capital ratios and conservative lending practices. Competent compliance for trusts and LLC onboarding. So we work with banks in Switzerland and other banks around the world to keep your funds secure within this trust structure. So digital access, so you can see your account online. Reserves should be SWIFT only with dual control on wires. So operating cash stays in your U.S. relationship bank, so that way you can pay your payroll. Reserve cash, however, lives offshore in the trust-owned LLC account. So different rails, different leverage. Okay, here's how the money flows: clean, reputable, and auditable. And by the way, somebody says, oh, this sounds complicated. Well, I'll tell you what's complicated is not being able to make payroll. That's complicated. This stuff is easy. This is what we do every day. So you can rely on the professionals, our law firm, to set up more of these than anybody. You leave the part that sounds difficult and complicated to the people to whom it's easy. Very, very easy to us. This is something we do every day of the week. So the key thing is, this is going to be the strongest protection to give you the peace of mind, not worrying, sleeping like a baby, and negotiating teeny tiny settlements when the lawsuit gun is aimed at you. Okay, so day-to-day flow. Revenue lands in U.S. operating accounts. So you get the income in your account monthly or quarterly. You transfer excess cash above working capital to the offshore reserve account right here. Okay, so so regularly you're shuffling money from your business account into your reserve account here. So that the money from your business flows in this direction. You keep your reserves here, and you can take it out whenever you like. So you're in charge of that. If operating needs spike, you repatriate, in other words, bring the funds from offshore, put them back to onshore as needed. So it's like using your own internal credit line. Control. You can have dual authorization for outbound reserve wires. In other words, you can have an employee to set up the wires and you approve them. The board/owner resolution defining thresholds and cadence. So you have this in the paperwork that proves prudence. Okay, cliffhanger number 3. In a moment, I'll tell you the number one mistake that hands plaintiffs leverage. The people suing you, that gives them leverage even when your structure is perfect. So first, the legal mechanics, governance. Now, the law loves paper. 3 simple artifacts can turn your plan from clever to credible in a courtroom. First of all, cash policy. 1 page. So the cash policy defines operating thresholds, reserve targets, and transfer cadence. Signed annually. You have your minutes and resolutions. So in the minutes and resolutions, you record the policy and the authority to open and maintain offshore reserve accounts. So it holds up in court. Next, you have your duress kit. The duress kit is a pre-signed manager resignation, the trustee notification protocol, and a 1-paragraph internal memo. If X happens, call Y. If a lawsuit happens, call the trustee. So store copies with your GC and your CPA in a deposition. Nothing beats calmly saying, we simply follow our written policy. Okay, here's what the law actually does. 4 features make this work. First of all, we put in a duress clause. So if a court orders you to turn over trust assets, the trustee must refuse under the deed that we put together for you, because you're only requesting that money under duress, not of your own free will. Give me the money because I want it is one thing. Give me the money because the judge ordered me to turn it over. That's a totally different set of instructions. So the trustee knows that you're not doing that under your own free will, and they'll refuse that request because they know you're not doing it voluntarily. Number 2, independent trustee. So this is a licensed bonded offshore law firm, and they follow the deed and local law, not a U.S. subpoena. The next defense is the impossibility defense. With the impossibility defense, you can't be compelled to do what is illegal under governing law. And we add to this, if you're requesting funds from the trustee, you have to sign under penalty of perjury. You're not doing this under duress. And the judge cannot force you to sign something that perjures yourself. So finally, short limitations and high burdens of proof. So creditors face compressed timelines. So this is a statute of limitations on fraudulent conveyance, saying that you move money into this trust to keep it away from creditors. Well, you didn't. And it's pretty hard to prove. In the Cook Islands, your plaintiff or judgment creditor only has a very, very short timeline to be able to challenge this arrangement. And even if they do, they're going to lose. But once that time passes, they can't even challenge it. Plus, they have high burdens of proof. So they must prove that you did this to keep the money away from them beyond a reasonable doubt. We've never seen anybody win that case. And like I say, I've been doing this for almost 30 years. So creditors face compressed timelines and heavy proof burdens. So to unwind legitimate planning when it's set up right is almost impossible to do. So I've been in asset protection business for 34 years, setting up Cook Islands Trust for nearly 30 of those. So our experience and the public record support this. No Cook Islands trustee has been forced to hand over properly structured trust assets for trusts that we've set up to satisfy U.S. civil judgments. Our licensed bonded trustee company has never absconded with client funds, and our reputable professionals protect their licenses like treasure. Okay, next, timing, funding, and the too late problem. Okay, let's say you're already in litigation. You still have options, but the runway is shorter. Courts evaluate intent and timing. Best practice? Bake the structure into governance before disputes. Move excess cash on a schedule tied to metrics. For example, balances above 90 days of expenses. Shift to reserves quarterly. Look like risk management, not panic. In a dispute now, talk to counsel. We have attorneys on our staff that specialize in asset protection. There are compliance steps, but the analysis is nuanced. Cliffhanger number 4, what's the one-page document, as promised? It's not a trust, it's not a bank form, but we're getting close. Okay, here's a case study. I like to kind of illustrate this with an actual situation. Composite. Alex ran an $18 million ARR SaaS company, operating cash $2.5 million to $3.1 million. Reserves, $6.5 million in one U.S. bank, same signature. An ex-partner filed a suit with the TRO, temporary restraining order request. So we had formed Alex's Cook Islands Trust plus LLC 9 months prior, but he hadn't funded it yet. So when the hearing was set, he executed the board-approved transfer, $5 million to the offshore reserve, leaving 120 days of operating onshore. So the judge declined to freeze the operating account. The reserve was offshore under an independent trustee. The outcome? Nuanced settlement. The offshore reserve changed the economics, and the opposing counsel later admitted that. So here's another case study. Composite. A physician-owned group held $3.8 million in retained earnings. A vendor dispute escalated, and then months before the suit, we implemented the offshore reserve. So when litigation hit, the duress clause triggered the trustee oversight. Payroll never skipped. The vendor's voluntary repatriation demand was refused under duress. They pivoted to arbitration and settled commercially. Now let's talk about taxes and reporting. Now this whole setup is not tax evasion. Income remains reportable. U.S. persons file required foreign accounts and asset reports when applicable. Coordinate with your CPA. The goal is separation and survivability, not secrecy. So here's compliance in a nutshell. Names you'll hear. If you're a U.S. person, you'll likely hear acronyms like FBAR, FinCEN Forms 114, FATCA, IRS Form 8938 for reporting foreign accounts and assets above certain thresholds. Trusts and foreign entities have their own filing forms depending on how they're treated for U.S. tax purposes. Your CPA will advise. So think information returns rather than extra tax. So our job is to align the legal structure with your team so the reporting is complete and painless. The goal? Clean, predictable compliance. Okay, the number one mistake is commingling. So treating the reserves like a slush fund, ad hoc draws, random bill pay turns a fortress into a revolving door. So here's the fix. Write and follow a cash policy. Define operating thresholds, reserve targets, movement rules. Use minutes and resolutions, dual controlled wires, no casual commingling. Okay, here's cliffhanger number 5. The two founder-friendly power-ups are next, and then the one-page document I promised. Okay, the one-page document. The management and resignation under duress pre-signed. And that triggers only when you're under legal duress. It resigns you as the LLC manager, instantly shifting management to the independent trustee company or protector under your trustee. The result? Squeezing you won't open the reserve vault. Plaintiffs must litigate offshore under offshore law on their dime and timeline. Most won't. In fact, we've never seen any of our clients, we set up a trust in the Cook Islands, have to fight that battle because, the plaintiff, judgment creditor, no, they're not going to win. Okay. Next question we get asked. What if the bank fails? Okay, that's a fair question. The plan is the legal structure. The bank is simply the tool. So that's why our priority is Swiss banks. That's what we recommend the most. And we've never seen a client lose a deposit from our Swiss banks ever. With custody and multiple counterparties available, we can migrate under the same LLC and trust. If an institution changes their risk posture, we can switch to Liechtenstein, Luxembourg, some of the safest banks in the world. So the shield, that is the LLC and the trust, travels with you to the next bank if you want to switch banks. Cliffhanger number 6. Here's the exact onboarding sequence so that you can see how fast this becomes normal finance rhythm. Your Offshore Cash Playbook, the Founders Edition. So if you want a full deep dive, grab my offshore banking checklist down in the description. But here's the quick start version that you can picture right now. First of all, take inventory. Figure out how much cash you really need at home to run payroll and keep the lights on. Everything above that, it's reserve fuel. Next, write it down. So you write it down. Approve a simple board note. Here's our reserve target. Here's when and why we move the money. Boom, governance done. Supportable in court. Next, build the vault. Create your Cook Islands Trust with the LLC inside of it with the all-important duress switch. So that's your legal bunker. Next, you add the keys. Drop in a Cook Islands LLC inside the trust. So this is the box that actually holds the bank account. Next step is pick the bank. We help with that. Open the reserve account offshore. Add dual control so no one person can push money alone. Set the rules. In other words, create a cash movement policy. Monthly or quarterly transfers tied to real metrics, not gut feeling. What are we doing here? What are we doing here? Remember, what we're doing here is we're taking the fear away so you don't ever have to worry about not making payroll because some ding-dong decided to sue you and take all of your cash. So that's what we're doing here. Next is the emergency brake. So this is an offshore banking checklist to show you how this works in actual practice. The emergency brake is to put your manager resignation under duress in the glove box. That's your duress kit. So ready if a lawsuit comes calling. Next, test drive it. So move a small amount in and back out, kick the tires so the team knows how the system works. And finally, with a quarterly tune-up, review. Are you following the rules? Do the thresholds still make sense to you at scale? So adjust and repeat. So that's it. Not scary, not complicated. Think of it like upgrading from a padlock to a biometric vault door for your company on a rainy day, giving you peace of mind. You never have to worry about the lawsuit taking everything you have again. Okay, now for extra credit, here's some FAQs, a lightning round. Can I invest the cash reserve? The answer is yes, with a conservative liquid policy. You can put it in stock or whatever. So this is a vault, not a casino. Will my U.S. bank dislike offshore transfers? Well, predictable cadence and documentation keeps the relationship calm. So in other words, just explain it. I mean, we have offshore transactions almost every day of the week, and the bank understands because it's what we do. We do a lot of international business. Next, can a judge order repatriation? Can they order to bring the money back? So the answer is, well, they can try. Under duress, you don't control the reserves. The independent trustee company law firm follows the deed and the local law, and like I say, they're the most regulated trustee jurisdiction in the world. Is the Cook Islands the only option? Well, it is the gold standard. Belize, down Central America, and Nevis, down southeast of Florida, are also really good options. So we tailor it as needed. The architecture stays the same. So just long story short, Cook Islands Trust is our first choice. If you're already in litigation right now, a lot of times we'll go with Belize because they're a lot more friendly to people who are already in the battle. Okay, so here's some objections I hear every week with some straight answers. So won't this spook my investors or lenders? Well, when documented as risk management, just like cyber insurance or key man, sophisticated parties really appreciate the prudence. We've helped multiple clients explain the policy in board decks in under 2 slides. Next, will this slow me down operationally? No. Operating cash stays domestic with full speed. The reserve is designed to require deliberation, not daily access. Next, can I just diversify in U.S. banks? Well, it's helpful, but it's inadequate. Jurisdiction and personal compulsion are the issues. 5 onshore banks still are under one court's power. All right, now founder mindset, calm as a process. Elite operations treat cash like oxygen. Separating operating reserve money guarantees that your people breathe, even when somebody tries to put a hand on your throat. If you like control, great. That's why you manage the LLC while the skies are clear. Our licensed, bonded, trustee company law firm steps in only when we need it. They only step in when somebody would take all the money away. So you want somebody who's never taken money away to step in to protect you, because that's what they do. So use when calm, protection when stormy. Okay, one final case study, the e-commerce roll-up. Composite. Diana ran 8 brands with seasonal cash, $9.2 million reserve after Q4. A competitor filed in a plaintiff-friendly venue aiming to freeze cash before Prime Day. Because reserve sat offshore in the trust-owned LLC, they couldn't pressure her with freeze now, settle cheap. Operating accounts held 120 days of runway. Jurisdiction failed. They settled for a licensing deal. So payroll hit every Friday. Customers never saw the storm. So if you're a founder holding $1 to $10 million in cash reserves and you don't have a separation plan, let's fix that. Go ahead and look down in the video description down below. Copy and paste the offshore banking checklist and schedule a consult at assetprotectionplanners.com. In fact, I publish playbooks like this weekly for business owners and real estate entrepreneurs. So subscribe so you don't miss out on the next deep dive. Okay, here's what we actually do, no hype. So we design the Trust Plus LLC architecture here. We also do the onshore planning with the onshore LLCs, companies, liens, equity stripping for your business and for real estate. We coordinate with banking, align your CPA with reporting, and train your finance team on the cash policy. So after nearly 30 years setting up Cook Islands Trust, we know where friction appears and how to remove it. In fact, our firm is, like I say, set up more Cook Islands Trust than any firm in the world, bar none, predictable, compliant, focused on keeping your company breathing through any storm. So the big picture and your quiet flex is this. You built a war chest. Don't leave it in the lobby with your name tag on it. Put reserves where they belong. A vaulted room behind law designed to say no on your behalf. The quiet flex isn't flashing onshore balances. It's the calm you feel knowing Friday payroll happens no matter what files land on your desk on Wednesday. One plaintiff shouldn't control payroll Friday. So now you have the playbook to make sure they never do. I'm Kevin, the business guy and the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. Links are below, and we'll see you in the next one.